subject to the result of this petition. Much case.
Cell number 26, Prasanna VR for petitioner.
The petitioner
Ajay Jayan. For petitioner, connected matter. Ajay Jayan.
Back to appear for the petitioner. Second matter.
That is a completely different issue. 26 is a complete. This is a different. This is on examination matters. This will continue. Argue. Start arguing. One matter is taken, other matter will not. Therefore,
I will make my submissions.
Whatever that matter will start, they have a chance to be continued at 2:30. Yes,
I will make my submission, my lord. My second matter may be taken up, my lord. WP number. Third matter, my lord. WP number 953 of 26. My lord. There, save. The kind permission. Mic.
953.
Yes, ma'am. Kind permission, my lord.
Yes.
Lord, I have raised two main contentions, my lord.
Yes.
Regarding Kannada examination, and secondly, my lord, the Hyderabad Karnataka reservation issue, my lord. Hyderabad Karnataka reservation point,
Yes.
which they have altered during the process, my lord, and the how examination which is conducted in the Kannada paper, my lord, is impermissible according to us, my lord, for the petitioners, my lord.
No, that where is Prithvi? You have raised what is the ground?
I have raised that first ground is on the minimum mark. Whether minimum qualifying mark must have been set, and in that whether relaxation should be given to the scheduled caste.
Is goes.
Yes.
How in the Kannada other why should I hear and have it in that mind? Let it go. If he convinced
Yes, ma'am.
in that point, then entire notification will go. If he fails, then we'll go to that next point.
Yes.
Whether that examination is conducting or not. Why do you want to go to that your sister?
Even in our case also, my lord, they cannot hold Kannada examination itself. That is our contention. Even that, if that is all, my case is also allowed, even the entire process as far as the holding of Kannada examination is concerned, that will be that will be cancelled. Whatever is relating to the technical papers, that will remain intact, my lord. Only they have to conduct Kannada examination.
No, but he is arguing that the entire, if it is succeed, the entire notification has to go, Mr.
Yes.
Then your socialist, they can go ahead with that without Kannada examination.
That is the point.
That is for
they can. But
yours is that part of the notification has to go.
Yes.
He is arguing that the entire notification has to go.
Yes, ma'am.
I will hear first.
Yes, ma'am.
I don't want to waste.
Why? Because, my lord.
If
Why?
his case is out, then I will come to your case whether.
I am in the top of the list. What I'm trying to say is my technical examination result has to be intact. I'm only challenging the holding of the Kannada examination because it is affecting me in the manner in which they are conducting. I'm not at all challenging the entire.
He is challenging.
He is challenging. If he succeeds, yes. And even this issue has to be decided because they cannot hold even if he succeeds.
If he fails,
Yes. Yes.
then I will come to your case.
Please.
Yes.
My.
Otherwise, unnecessary hearing.
Yes.
Suppose if he succeeds,
Yes.
if said that no, you do it first notification.
Yes.
Then you have also satisfied that.
Yes. And my point has to be answered because they cannot hold Kannada examination. Once again.
Again, they issued a Kannada examination. Then you can.
Yes. Yes. Grateful.
Yes. Now, which is that matter we want to argue?
39094, the first one, my lord.
First one.
Yes.
Yes.
It's If learned AG is appearing, my lord, that is convenience. I can argue subject to your lordship's convenience.
By the time he will come now. He's coming.
My lord,
today.
I spoke, message the AG, here.
He is ready today. Because of
No,
you or urgency only, I am
Yes,
taking
yes,
that
yes.
matter.
My lord, let him argue the matter. My lord, we'll reply by afternoon or by tomorrow, my lord. Depending on if he makes any additional points, I
Very well.
reply.
No, it's better.
Yes, my lord.
I don't want to
If
make
it
it
can be at
parted by
2:30,
so many
my lord.
matters. One stretch.
Yes, if it can
My
be
lord,
at
can it be at 2:30? My lords, because Prithvish had informed us yesterday. So based on that, my lord, then today morning, PS Rajgopal sir called me and said, I have inconvenience, Ajay, my matter at 2:30. Or will not
ಅವ್ರದ್ದೇನ್ matter ಅದು?
the elevation scheme, Swami, that's the existing employees matter. That is affecting the promotions of the existing employees. This, my lords, is recruitment.
Then that is the different. That
It's
will
completely
take some other
completely
day.
different.
Which is that? I will,
Yes.
you can continue.
Yes, sir.
Yes. You can inform that Rajgopal will take that matter in some other day.
Yes, I will.
We'll inform.
Yes. Yes.
Let the, I'll just give the facts minutes, first facts minutes.
Yes.
Let annexure B, page number 33.
Yes.
On 17/7/2017, my lord, the recruitment notification was issued, page 33.
Yes.
Let's recruitment notification number reference is given, my lord.
Yes.
17/7. But thereafter, the number of posts vary, my lord. Therefore, we can take 3/8/2017, my lord. That's the date of recruitment notification, my lord.
Yes.
Let the recruitment notification was issued for various posts,
Yes.
including assistant engineer, electrical, civil, mechanical, junior engineers, chemist, chemical supervisor, so on and so forth.
Yes.
Let your lordships may see, my lord, the recruitment notification
Yes.
at page number 37, para 6, my lord.
Yes.
Selection procedure. Selection will be made purely on merit basis, duly following reservation policy. Merit list will be prepared based on marks obtained in the written test.
Yes.
Now, my lord, para 7, as to how the written test will be conducted, my lord.
Yes.
That they say, my lords, candidate may that the exam center will be in various places.
Yes.
That is Bangalore, Ballari, Shimoga, and we can indicate any 2 tests.
Yes.
Clause 8 is, my lords, Kannada language test, that they will have to pass the Kannada language test.
Yes.
If they have not, my lords, qualified in the Kannada, in SSLC or so on and so forth.
Yes.
My lords, this was the recruitment method, my lords, that was adopted.
Yes.
Recruitment examination, my lords, in terms of the recruitment notification was conducted for the first time, my lords, in the year 2018.
Yes.
My lords, that examination, my lords, came to be cancelled, which your lordships, my lords, would find annexure D, page 45.
Yes.
Let's the respondent corporation, my lords, on its own volition would cancel the recruitment process, my lords.
Yes.
This cancellation of the recruitment process, my lords, came to be challenged before your lordships, my lords, before a single bench, before a division bench. All of them failed. Ultimately, this honorable court also directed for redoing the examination process and upheld annexure D.
No, this is cancellation of
Yes,
examination.
21/1/2018. This is the first exam.
Written test held on so and so has been cancelled. Re-examination will be conducted. What is the reason for cancellation?
My lords, that there was various malpractice, so on and so forth.
It's they are voluntarily.
Yes, voluntarily cancelled.
Yes.
This was the first exam.
Yes.
And first cancellation is on 23/6/2018.
Yes. Yes.
Then comes annexure E, page number 46.
Yes.
But under annexure E, page 46, KPCL would hand over the process of conducting the examination to the Karnataka Examination Authority, KEA. That is annexure E, page number 46.
Yes.
Pursuant to that, annexure H is the examination conducted by the Karnataka Examination Authority.
Yes.
That's the question booklet. Now, what happens at page 51?
Yes.
After the examination is conducted at page number 51, a paper publication is published. Every wrong answer, 1/3 negative marking is will be deducted from the score. My lord.
Yes.
That is annexed page 51,
Yes.
annexure J.
Yes.
My lord, the annexure J
Yes.
was put to challenge, my lord, before this honorable court at page number 59.
Yes. Yes.
My lord, not these petitioners, my lord, some two persons, my lord, challenged the annexure J and the score, my lord, that was published based on the negative marking.
Yes.
My lord, the learned single judge of this court, my lord,
Yes.
dismissed it on two counts, my lord.
Yes.
The first ground on which the writ petition stood rejected, which your lordships would find at paragraph number 7, page number 67.
Yes. Yes.
Page 67, para 7, my lord.
Yes.
The first contention, the first ground on which, my lords, the writ petition is rejected is in the 2018 examination, negative marking was notified. This is only a re-examination. Therefore, it is implied that the conditions of the earlier exam are followed here. That is the first.
Yes.
The second ground is para 10, my lords.
Yes.
Para 10, page 70 onwards.
Yes.
Learned single judge of this court would hold, my lords, that having participated in the examination, they rely upon the leading judgment Madan Lal, which is followed various months.
Yes.
Page 70. That having participated in the selection process, you can't challenge it. You can't turn around, having been unsuccessful. Therefore, my lords, on these two grounds, writ is dismissed.
Yes.
My lords, thereafter, writ appeal is preferred at page number 78.
Yes.
Is one of the writ appellants, though he was not a writ petitioner.
Yes.
Along with IF for permission, writ appeal is filed.
Yes.
Page 78, appellant 2, my lords, is petitioner number 1 here.
Yes.
Writ appeal came to be filed, my lords.
Yes.
In the writ appeal, my lords, after hearing all the parties, this honorable court, my lord, I'll take your lordships directly, my lord, I'll take your lordships to the findings a little later. But ultimately, my lords, this honorable court, the operative portion is at page 124.
Yes.
My lord, in the meantime, my lords, during the pendency of the writ appeal,
Yes.
the selection process was underway. My lords, there was an understanding that they will not publish the final select list and issue appointment orders. Therefore, my lord, it was kept on hold. No appointment orders were issued. Final select list came to be issued at page 124, my lord.
Yes.
Writ appeals are allowed. Order of learned single judge in so-and-so are set aside. Notification bearing number so-and-so. The final score list dated 12/6 and the provisional score list 8/5/24 are quashed. Respondent number 1 to 3 are hereby directed to conduct a re-examination expeditiously and within reasonable time for all candidates appeared in examination of 24 pursuant to the notification dated 2017. Direction is to redo the exam for all the candidates who are appeared in 24.
Now,
The
what about that negative scoring?
They held that negative is bad. Next direction is that, my lords. The re-examination shall be conducted subject to the condition of negative marking, and such condition shall be expressly communicated to all candidates much before the examination.
Yes.
My lords, this order was put to challenge the order of the division bench.
Yes.
Directing re-examination was put to challenge at page 126, my lords.
Yes.
My lords, the contention before the Supreme Court, my lords, initially was that if negative marking is taken away, then the scores can be recalculated and whoever is eligible can be appointed. My lords, it appears that found favor with the Supreme Court at page 127, my lords.
Yes.
We are at the High Court on the question of law that negative marking could not have been introduced without letting the candidates know that an incorrect answer would lead to marks being deducted. If at all considered essential, the candidate should have been clearly made aware of it before the process. Be that as may, the direction contained in the operative part of the order for conducting re-examination would unnecessarily burden the public exchequer. Apart from time and effort being spent, it is also likely to affect the candidates who had taken the qualifying exam knowing fully well there would be no negative marking with serious consequences. In our considered prima facie view, interest of justice would be saved if re-evaluation, reassessment of the answer sheets of all candidates who had taken the qualifying exam earlier is undertaking without negative marking.
Yes.
Then, my lords, at page 129 on the next date of hearing, my lords, page 130.
Yes.
Para 1, my lords.
Yes.
The so-and-so learned Advocate General for Karnataka appears for the respondent corporation and submits that the vacancies having remained unfilled since 2017 and to avoid heartburns amongst the candidate interested in employment, he requires some time to obtain instructions from the state as to how the concern could be addressed, which would necessarily include a decision taken at the level of the cabinet. Then, my lords, para 4. Having regard to the special, it would be desirable if the government as one-time measure proposes a closure of action ensuring to the benefit of candidates who participated in the process of selection as far as practicable. Now, the proposal was, my lords, to include both sets of candidates, my lords, with negative marking, without negative marking. Whoever is excluded, try and accommodate both so that it can. Then at page 131, my lords.
Yes.
My lords, ultimately, my lords, the Supreme Court, my lords, notwithstanding the earlier directions, my lord, at page 132,
Yes.
would dismiss while undertaking the recording at para 4. We record the submission of Mr. So-and-so learned additional so-and-so for the state of Karnataka that the retest shall be conducted within 4 months from the date of the order. Now, my lord, this was the order passed.
Yes.
My lord, in the meantime,
Yes.
the order of the division bench was pending in review, my lords, page 133.
Yes.
My lords, the review also ultimately came to be dismissed, my lords, on the ground that Supreme Court has also dismissed and negative marking has not been seriously urged, page 138.
Yes.
Now, my lords, the review petition, the order in review petition at page 138,
Yes.
which starts, my lords, at page number 133, was again put to challenge before the Supreme Court.
What is that review order you are challenging? It has been.
Yes, my lords. The review, page 133, my lords, it
Yes.
starts. The petitioner in the petition your lordships are holding, my lords, since he was the appellant, he had filed a review, my lord, saying that re-examination is not necessary. At best, only recalculation of marks. Now, my lord, since those contentions were rejected, the division bench also rejected the review.
Yes.
And then, my lord, SLP was preferred against that order also. Against the review, which came to be rejected, my lords, on 19/12/2025.
Yes.
Now, my lords, in the meantime, pursuant to the first order, the order of the division bench, my lords, the re-examination had to be conducted. Page number 31, Annexure A. This was the re-examination notification pursuant to the order of the division bench. Lord, your lordships will note, my lords, 27/12, 28/12 are the dates of the technical examinations. 28/12, last one, my lords, is the Kannada language examination. Now, my lords, page 32 are the instructions, my lords. Page 32,
Yes.
my lords, clause 4, my lords. ಸೂಚನೆಗಳಲ್ಲಿ ಕ್ಲಾಸ್ 4 ಮೇಲ್ಕಂಡ ಮರುಪರೀಕ್ಷೆ OMR ಮಾದರಿಯಲ್ಲಿ ಆಪ್ಟಿಕಲ್ ನಡೆಸಲಾಗುವುದು. ಅಧಿಸೂಚನೆಯನುಸಾರ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕನಿಷ್ಠ ಅಂಕಗಳನ್ನು ಗಳಿಸುವುದು ಕಡ್ಡಾಯವಾಗಿರುವುದಿಲ್ಲ. It is only this examination notification which made it clear that we will not prescribe the minimum marks.
Now, what was the negative scoring? How that they are doing negative scoring there?
Originally, there is in the recruitment notification, there is nothing about negative marking.
Can you how they was doing earlier negative scoring in that subsequent notification?
For every wrong answer,
1 mark.
1/3 marks.
1/3.
1/3, 0.3 marks, my lord, would get deducted.
Yes.
Now, my lord, in clause 5, they said, as per the recruitment notification, there will be no minimum marks prescribed. The recruitment notification did not prescribe anything. This notification, they said, my lord, that it is not mandatory to score minimum marks. My lord, I'll explain to your lordships, my lord, while I raise the content.
The directions of the Supreme Court is that
Redo, there is no direction, my lord. The undertaking before the Supreme
it's kept open for everything or only that
redo the entire test.
yes,
That is, in fact, the direction of the division bench also is redo the examination.
yes.
Now, my lord, clause 5, they specifically said no minimum marks. Clause 6, my lord, ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನವಿದ್ದು ಪ್ರತಿ ತಪ್ಪು ಉತ್ತರಕ್ಕೆ 1/0.3 ಅಂಕಗಳನ್ನು ಕಡಿತಗೊಳಿಸುವುದು. 1/3 marks will be deducted for every wrong answer.
That negative scoring is there.
Yes, man. Because there was a direction by the division bench to make it explicit. It was clause 7. ಪಾರದರ್ಶಕತೆಯ ಭಾಗವಾಗಿ ಉತ್ತರಿಸದೇ ಇರುವ ಪ್ರಶ್ನೆಗಳಿಗೆ 5ನೇ ಆಯ್ಕೆ ವೃತ್ತವನ್ನು ಶೇಡ್ ಮಾಡಲು ಕೊನೆಯ ಬೆಲ್ ಆದ ನಂತರ ಹೆಚ್ಚುವರಿಯಾಗಿ ಪ್ರತಿ ಪ್ರಶ್ನೆಗೆ 1/3 ಅಂಕಗಳನ್ನು ಕಡಿತಗೊಳಿಸುವುದು. Not only is it for a wrong answer, even if I don't choose an answer, even if I don't mark anything, 1/3 marks will be deducted. Next, Malad.
All that you can't say that wrong. It is for all.
Yes, Malad. It is for all.
It cannot be that only for
No, Malad. Not only for. It is for everybody, Malad.
yes.
Clause 8. ಕನ್ನಡ ಭಾಷಾ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಅರ್ಹತೆ ಹೊಂದಲು ಅನ್ವಯಿಸುವ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಕನಿಷ್ಠ 35 ಅಂಕಗಳನ್ನು ಗಳಿಸುವುದು ಕಡ್ಡಾಯವಾಗಿರುತ್ತದೆ. Minimum marks, my lord, was prescribed for Kannada examination only. ಪರೀಕ್ಷೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ಜಿಲ್ಲಾ ಕೇಂದ್ರದಲ್ಲಿ ಮಾತ್ರ ನಡೆಸಲಾಗುವುದು. Now, my lord, this was put in challenge. This is under challenge before your lordships, my lord. But there are two other facts, my lord, which are not borne out in this writ, but in the connected writ. First is, my lord, after the re-examination before the single judge order here, my lord, the Kannada language test was challenged before the Gulbarga High Court, my lord. Where they prescribed the minimum marks after the examination. Therefore, my lord, the Gulbarga High Court, single bench of the Gulbarga High Court held, you can't do that. You have to prescribe it before. Now, my lords, there's an express direction there to prescribe the minimum marks before the examination is conducted, insofar as Kannada language examination is concerned.
Now they have prescribed.
That is why they have prescribed. Now, my lords, the second fact is on 10/12/2024, my lords, 2025, they would publish a notification, my lords, that is in the connected writ petition, which your lordships would find, my lord, sir, Mahalakshmi Dhumna, last matter,
2328.
yes, yes, 27.4.
Yes.
Let's page 234 in that minute. On 24/12/2025, 234. This is before the examination.
Yes.
I'm taking advantage of this minute.
Yes.
Circular. A circular dated 10/12/25 was published on KPCL website, wherein at serial number 3, it was dated that selection lists will be prepared as per Government Order 3625. Subsequently, certain candidates have raised objections stating that since recruitment process commenced in 17 under the rules of dated 16/11/2016, applying 25 rules is inappropriate. They have requested withdrawal of notification dated 10/12 and preparation of the select list as per 2016. In this regard, it is hereby stated that KPCL will come under circular dated 16/11/16, which was further clarified by notification dated 3/6/25. Accordingly, both notifications are applicable to the examination scheduled on 27 and 28. Therefore, my lords, KPCL says we will apply 2016 and 2025 circulars.
How can that both?
Both, my lords. My lords, page 235 and 236 are the two circulars, my lords.
Is it conflicting or they
No, my lords, they are in pari material.
Yes.
Page 235.
Yes.
The clause that I rely upon is clause 2. This is the circular, 2016 circular, which they say, my lords, they will follow. I have no difficulty. Clause 2, my lords.
Yes.
May I read clause 2 at page 235?
Yes.
ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಇನ್ನು ಮುಂದೆ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಹಾಗೂ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ ಅಧಿಸೂಚನೆಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆ ಅಂತಿಮಗೊಳಿಸಲಾಗುವುದು. It said for local cadre and for Hyderabad, Karnataka, two separate notification, two separate methods of recruitment.
Yes.
Two separate recruitment processes should be conducted.
Yes.
In this case, my lords, there are two separate recruitment notification,
Yes.
but the selection process becomes combined by conducting only one examination.
Yes.
Now, the 25 circular which they say they will follow, my lords, annexure Z3, page 236,
Yes.
3625.
Yes.
My lords, at page number 237,
Yes.
my lords, clause 2 is what they will rely upon.
Yes.
Before I read that, can I read the last portion, my lords?
Yes.
ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಈಗಾಗಲೇ ನೀಡುವ ಸೂಚನೆಗಳಂತೆ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕ ಪರೀಕ್ಷೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. 2 different examinations shall be conducted. ತಪ್ಪಿದ್ದಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳನ್ನೇ ನೇರ ಹೊಣೆಯಾಗಿ ಮಾಡಲಾಗುವುದು. Let's kindly note the date of this notification 3625, which is at page 236, and at before the examination on page 234, 2412, they expressly make a notification saying we will follow 3625.
Yes.
Now, my lords, please have page 237, clause 2, which they will rely upon today, my lords. Page 237,
Yes.
clause 2. My lords, I have relied upon the last portion.
Yes.
They are relying upon column 2. ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ಕೈಗೊಂಡಾಗ ಅನುಸರಿಸಬೇಕಾದ ಕ್ರಮ: ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಪಡೆಯಲಾದ ಆಯ್ಕೆಯನ್ನು ಪರಿಗಣಿಸದೆ ಮೆರಿಟ್ ಪಟ್ಟಿಯಿಂದ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸಿದ್ದಲ್ಲಿ ಸ್ಥಳೀಯ ಮೊದಲಿಗೆ ಮಿಕ್ಕುಳಿದ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗೆ ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ತಯಾರಿಸುವ ತದನಂತರ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಪರಿಗಣಿಸಿ ಅರ್ಹ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸುವುದು. 2, my lords, transpose those who are meritorious in HK to non-HK and prepare the merit list. My lords, this clause will apply
Yes.
if the examination is conducted prior to 3/6/2025. Clause column 2.
Yes.
If it is not, the last portion, my lords, kindly see the direction there. ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ಹುದ್ದೆಗಳಿಗೆ ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಈಗಾಗಲೇ ನೀಡುವ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕ ಪರೀಕ್ಷೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. So as on the date of the examination was conducted, 3/6/25 was available,
Yes.
which they say, my lords, that we will follow. And even in the 2016 circular, which they say will apply,
Yes.
clause 2 said there shall be 2 different recruitment processes.
Yes.
Now, therefore, my lords, challenging on these grounds, my lord, we have approached this court. I'll just set out the brief grounds, my lord.
Yes.
I've served a copy on the other side. I've summarized all of them.
Yes.
My lords, your lordships may kindly note, my lords, that we have approached the court before the exam was conducted. The first petition, my lords, they have approached before the exam was conducted.
Yes.
My lords, the first ground that we have raised is, my lords, that there is no stipulation of minimum marks in the exam notification. But the response of the respondent, my lords, in the statement of objection is twofold. One, in the recruitment notification, we have not prescribed minimum marks. Therefore, we need not prescribe. We are only telling what the recruitment notification. Second is, in the earlier exam also, it was not prescribed. This is only a retest. My lords, I have an answer to both of that. First, let me show your lordships the rule, my lords. Your lordships will find that rule, my lords, at page 144, my lords.
In which petition?
In the first, your lordships have the second petition.
No, first petition only, yes.
First petition.
Yes.
Your lordships may have the second petition, my lords. It has
39094. Second petition.
second petition, page 165, my lords.
Which you are
Let's
referring.
Mahalakshmi Jumna. That 2-3. That is the most comprehensive. Your lordships may refer.
Yes.
Let's page 163, my lords.
Yes.
Let's can I read that clause, my lords?
Yes. 3328. Okay.
Since the Hyderabad Karnataka notifications were in the second one, I'm only referring to
Yes.
page 163, my lord.
Yes. Which annex?
Annexure T. Just give me this. Let's clause 3.3.3. For the written test to be conducted, the MD will nominate the authority to conduct the written test. Specify the minimum pass marks for general category
Yes.
with relaxation up to 5% marks
Yes.
for SC/ST candidates. Now, my lords, therefore, my lords, 3.3 in my respectful submission is first, for general category, minimum marks has to be stipulated. Second, for scheduled caste and scheduled tribe, only these two category of candidates
Yes.
will get relaxation of 5% of marks.
Yes.
Now, my lords, this is the statutory rules, my lords. The recruitment rules prescribe this. Now, my lords, the contention of the respondent is the recruitment notification did not prescribe, therefore we will not. My lords, the law is before the exam is conducted, the minimum marks can be prescribed. It need not be prescribed, my lords, in the recruitment notification. Please have a look at the impugn notification itself. Recruitment notification insofar as Kannada language test does not prescribe the minimum marks.
Yes.
But the impugn notification, my lords, prescribes the minimum marks for only Kannada.
Yes. Annexure?
My lord, annexure A.
Yes.
Annexure A. Only insofar as Kannada, my lords, at page number 42 prescribes the minimum marks because last time they did not prescribe it.
Yes.
Single judge of this court held, my lords, that it has to be prescribed before the examination. Therefore, my lords, they have prescribed it. And they are passing on the judgment for your lordship. My lords, your lordships may.
Yes.
Where is
Yes.
Geeta Chauhan? Geeta Chauhan. My lords, I'm sorry, my lords, it's not annexed to that. My apologies, my lords. I'll just place it on record, my lords. It seems to have been missed in the list. I'm sorry, my lords. My lords, my learned friend Ajay was also there, my lords. Both of us contested that. Where they specifically, in terms of the recruitment rules, I'll just show your lordship the recruitment rules insofar as Kannada language examination is conducted.
Yes.
My lord, the recruitment rules at annexure T, your lordship may just. The Kannada language test, my lords, there was a specific condition that insofar as Kannada language test, minimum marks will have to be prescribed as at 3.3.3.
3.3.3 is
No,
3.3 is
similar. 3.3 prescribed minimum marks for technical examination.
So where is that Kannada examination?
Yes, my lord.
Under
I'll
C
just.
and R.
My lord, your lordships may come to page 166, my lord.
Yes.
Clause 4. 4.5.
Yes.
No person who is eligible for appointment to any post in the cadre of AE equivalent and below shall be appointed to the post on the ground of his selection unless he has passed such Kannada language test as may be prescribed by the corporation,
Yes.
so on and so forth, my lords. Note, the language test shall be for 100 marks and its standard will be at the level of third language.
Yes.
Therefore, 4.5 clearly said you must have passed. Pass means there has to be a minimum marks, we have to score above that.
Therefore, court said that you have to.
You have to prescribe. There, my lords, the challenge was only specific to the Kannada language examination. Therefore, my lords, in this recruitment, while exam is being notified, they said that we will prescribe minimum pass marks for Kannada.
You have no grievance for that.
No, my lords. Now, in so far as technical is concerned, 3.3, my lords, though it's stipulated that minimum pass marks shall be prescribed. They say, my lords, that the recruitment notification did not prescribe, therefore we will not prescribe. Recruitment notification respectfully need not prescribe. It can be prescribed before the exam is conducted. That is where, my lords, the impugn notification comes into picture, where they say, we will not prescribe. Had they not said that, my lords, it's a different matter. But when they categorically say there will be no minimum marks, it is violative of 3.3.3.
Yes.
One, because general category candidates, my lords, do not have a minimum marks.
Yes.
And by not prescribing, the benefit that is available to scheduled caste and scheduled tribe by virtue of the recruitment rules
Yes.
is sought to be taken away.
Yes.
Both of which, my lords, are impermissible.
Yes.
I'll also show the judgment, my lords, where they said that before the stage is crossed, you can set the minimum marks.
Which is that?
That is the judgment in Tej Prakash, my lord. I just handed over to your lordship. It begins at page number 21, my lord.
Yes. Yes.
This is the Constitution Bench judgment, my lords.
Yes.
My lord, in so far, there, my lords, the question was, it was referred to the Constitution Bench for on reference because of the divergent opinions in the judgment in K. Manjushri,
Yes.
as well as in the judgment of Tej Prakash. Manjushri said after the recruitment has begun, you can't change the recruitment process. Then, my lords, the Tej Prakash said, would it apply in all cases? That your lordship will find at page 37, scope of reference.
Yes.
Then, my lords, page 40,
Yes.
they say, my lords, when the para 22, when the commencement of the recruitment process and end.
Yes.
Paragraph. Let's then at paragraph number 26, my lords.
Yes. Page.
Page 42.
Yes.
Then they go on the doctrine of legitimate expectation.
Yes.
Ultimately, my lords, while discussing at para 29
Yes.
on the decision of Manjushri, they would hold, my lords, that if the prescription of the qualification is before the stage has crossed, that it will start from clause para 29.
Yes.
It would end, my lords, at about the finding. I'm not reading it for paucity of time. Para 40, my lords.
Yes.
After discussing the facts of that case, they would hold, my lords, at ultimate conclusion is at para 62.
Yes.
where they say, my lords, you can't change para 65.2. 65.1 recruitment process commences from the issuance of advertisement calling for application and ends with filling up of vacancies. 65.2.
Yes.
Eligibility criteria for being placed in the select list notified at the commencement of recruit cannot be changed midway through the recruitment unless the extent rules so permit or the advertisement which is not contrary. Even if such change is permissible under the extent rules, the change would have to meet the requirement of Article 14 and satisfy the test of non-arbitrariness. Then, my lords, 65.4. Recruitment body subject to extent rules may devise appropriate procedure for bringing the recruitment process to its logic, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and rational nexus to the objects ought to be achieved. Extent rules having statutory force are binding on the recruitment body, both in terms of procedure and eligibility.
Yes.
However, where the rules are non-existent or silent, administrative instructions may fill the gaps.
Yes.
Let's 65.6. Placement in the select list gives no indefeasible right to appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. So therefore, my lord, they held rules have primacy.
Yes.
And that before the stage is crossed, the minimum marks can be prescribed, my lords.
Yes.
In fact, at page 29 onwards, Manjushri was with reference to the prescription of minimum marks itself, my lords.
Page number. Manjushri has been.
Manjushri has been extensively discussed, page 43, my lords.
Yes.
Let's page 45. If your lordships were to come, my lords, 27. This is where, my lords, therefore, introduction 27 within quotations, placitum B, my lords.
Yes.
Therefore, introduction of the requirement of minimum marks for interview after the entire selection process, written examination interview was completed, would amount to changing the rules of the game after the game was played. We may clarify that prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules, regulation, and selection can prescribe the rules, the minimum marks both for written or prescribed for written examination, but not for interview, or may not prescribe any minimum marks for either written exam. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe minimum marks, it should do so before the commencement of the selection process. Let's next 35 minutes. Kindly see minutes. The ratio in Manjushri is that the criteria for selection is not to be changed after completion of the selection process. Though in the absence of rules, the selection committee may fix minimum marks either for written examination or for interview for the purpose of selection. But if its minimum marks are fixed, it must be done before the commencement of the selection process. This view has been followed in so and so.
Yes.
Therefore, my lord, my first submission is, my lords, before the written examination was conducted, there is provision to fix the minimum marks, no doubt about it. But in the impugn notification, they say we will not fix, which is contrary to 3.3.3, my lords. And their only answer to that is recruitment notification is not done. And in the earlier time, we did not prescribe it. But in the earlier recruitment notification, my answer is twofold. The calculation of marks itself was put to challenge.
Yes.
Therefore, my lords, there's no question of saying that minimum marks was not prescribed, so on and so forth. Only if the calculation of marks was correct, my lords, question of minimum marks. Second is, my lords, my conduct is being, my lords, held against me. But what they say is the results of my conduct is taken away by judicial orders, for whatever reasons. But your conduct remains, the consequence of the conduct goes. It can't be that way, my lords.
Yeah.
If the exam is cancelled in toto, then it goes in its entirety. Today, they can't say previously you have participated, therefore it goes. Ultimately, today, your lordship, the selection is at a very, very nascent stage. Recruitment notification is there. For whatever reasons, earlier exams are cancelled. This is the first examination after the recruitment. So, therefore, my lord, these petitioners have approached your lordships at the first instance recruitment notification before the exam is conducted, we have approached your lordship. My lord, I have the judgment of Geeta Chavan, my lords, where they directed prescription of minimum marks. Now their case is it is only restricted to Kannada because the judgment was pertaining to Kannada. That's page 45, my lords. Yes, that's page internal page 31. Rule is quoted. The rule that I just read out to your lordships. Yes. Then, my lord, ultimately at page number 45. Yes. Conclusions are drawn. My lords. Yes. Fully relying upon Tej Prakash. They can't say minimum marks will be prescribed only for Kannada. And the second ground of challenge, my lords, in my summary of contentions, my lords, I have noted. Yes. C, my lords. They have relied upon circular dated 6/11/2016 and 36/25. I've given the page numbers. Para C, internal page 2, my lords. This is pertaining to Hyderabad, Karnataka. I read out.
Which is that next contention?
Page 2, C.
Illegal.
A conjoint reading of government circular dated 16/11/16 and 36/25 shows that where separate recruitment notifications are issued for HK and non-HK, separate selection process and examinations are mandatory. My lords, I have no difficulty in saying, my lords, when their notifications say that we will follow this, they should have conducted two different examinations. Now, in these batches of petitions, both HK and non-HK, general, SC, ST, all combinations are available. Therefore, locus may not be a question, my lords. My lords, next is merit solely based on written test is ultra vires, the statutory rules, my lords. My lords, the procedure prescribed in the rules of recruitment, my lords, which I just pointed out.
Yes.
My lords, I'll just take your lordships to the rules annexure T, my lords. What the rules prescribe, what is the methodology they have adopted, and their answer to that.
Where is that?
Annexure T, page number 162, my lords, it starts.
Where is that rule notification prescribed?
My lords, original, yes. Your lordships may kindly see, my lords, page number 57.
Yes.
My lords, your lordships got it.
Yes.
Selection will be made purely on the basis of merit based. Merit list will be prepared on the basis of marks obtained in the written test.
Yes.
Now your lordships may kindly see the rules or the amended rules, page 176. Page 177, relevant portion.
Yes.
My lords, the relevant rule would start at 3.3.2a, which is at page number 176.
Yes.
Lordship got 176.
Yes.
First one, my lords, in the column. Recruitment to the post in the cadre of JE, AE and equalist chemist headmaster will be made by selection considering the mark obtained in the qualifying examination and interview.
Yes.
This was the existing.
Yes.
My lords, in my first petition, my lords, I have relied upon the existing and not the amended. But in the first petition, I have filed a memo, my lords, since it has come. Now, kindly see the amendment of 2009. Recruitment to the post of JE and AE will be made by selection considering the marks obtained in the qualifying examination and the written test. Therefore, my lords, it's a two-stage process. One is the qualifying exam and the written test. Now, the recruitment notification says it will be only on the basis of written test and nothing of the qualifying exam. Now, respondents, my lords, seek to counter this on two contentions, my lords.
Yes.
My lords, this contention, my lords, is sought to be rebutted by the corporation, my lord, on two contentions. First is at page 111 of the reply statement of the corporation.
In this case,
Yes, my lord. They have filed
in which case they have.
100. But in the first case, they have filed reply, my lord. 3909.
What is their contention?
First contention is that there is a resolution to make it a one-stage selection process. Therefore, that resolution will prevail over the rules. Page 111 and 112.
111.
Yes.
Yes.
This is the 111 and 112.
Yes.
My lord, I am assuming, my lords, that this resolution will prevail over the rules.
Yes.
One, my lords, these are resolutions which can't prevail over notified rules.
Yes.
In the reply statement, they come up with this resolution, my lords. Candidates are not notified about this. But at any rate, please have a look at the last resolved at page 111.
Yes.
Resolved that the managing director be and is hereby authorized to carry out the recruitment process for entry-level posts as above in the two stages, keeping in abeyance the provisions for oral written test to the set post in the C&R rules on a one-time basis. Well, the resolution is in the year 2014, page 111 top. Page 112 is the second resolution, again of the year 29, 2014, at resolved point 1, my lords, last sentence. Modification of the decision of the board in its 230.
Page 112.
Yes, my lords. Other resolved.
Resolved.
First clause. Last but one sentence. Modification of the decision of the board in its 230 on a one-time basis only. So I am assuming modification is correct. It is only on a one-time basis, which stood, my lords, dissolved by virtue of
Completed.
on the basis of this for the very same post 112/2014.
It is completed.
Yes, that is not disclosed. That is not disclosed to your lordships at all. The only basis is that this modification takes place.
Yes.
Therefore, my lords, one-time measure is over. Second, over notified rules, statutory rules, executive instructions can't take place. My lords.
That is in which year that recruitment is over?
112/2014. Can I just place it for your lordships?
Yes. Yes.
There, my lord, the recruitment process is a one-stage recruitment process, my lord.
Yes.
And for the same post, AE, AEE, my lords, in fact, I have other notifications, but them I have got nothing to do with these posts.
Yes.
Therefore, that one-time measure may not strictly apply, my lord. Therefore, my lord, my submission is that the process, my lord, is contrary to the rules. My lord, and in so far as the fifth option, my lord, for negative marking, that the earlier round of litigation was for every wrong answer, there is negative marking. No doubt about it. But here is a case where even if I don't answer anything, my lords, I am bound to have negative marking, my lords.
No, that is, see, that is not contrary to that any rules. That is for the employers to fix.
Yes, my lords.
You cannot.
They can prescribe it before the exam, no doubt.
For the exams, it is not arbitrary. It is for everybody.
Very well.
You can't say that if it is for you too difficult, don't attend that exam.
My lords, if I don't attempt, then I will not have.
Means to say you are not interested. It's difficult.
Very
You
well.
don't want to recruit in this process.
Yes, my lords. My lords, therefore,
Can't say that because of exams.
yes, my lords.
I can't do it. You have to modify.
Yes, my lords.
Yes.
My lords, then I'll give up that contention for the present, my lords. I'll not press on that. Can I just show your lordships the judgments, my lords, which I rely upon, my lords?
Yes.
My lords, first one, my lords, was a judgment. I have given the propositions, my lords, in the list of citation.
Yes.
Where this was a case, my lords, if your lordships were to see from paragraph 3 and 4 onwards, there was participation in the selection process. Because today what is held against these candidates is, you have participated in the selection process, you can't turn around and challenge. Last time learned single judge held the same thing, which was reversed. Now, my lords, again we are...
Now, what is that finding of the division bench regarding that?
Yes,
What you have participated and
they said, unless you participate, my lords, kindly look at this. Unless I participate, I am an outsider to the selection, I can't question it. Without filing my application, I can't challenge it because I'm an outsider to the selection.
that is what that, or what is that judgment of the Supreme Court said? Once you participated, you cannot be.
Yes, ma'am.
That means to say, person interested on basis of the notification, you should be aggrieved and you have to challenge.
Before I file my application to the notification, I can't challenge it because I'm a stranger.
No, if you want, you want to apply for the notification. By seeing that notification, these are all the
Terms and conditions.
term and conditions, it is illegal. Then you can approach the court.
No, at that stage, I can't.
Why?
All the judgments, including Madan Lal, which was relied upon, were cases where I file my application, I participate in the written test, I go to the interview. There, in the interview or in the document, I become unsuccessful. Then I can't turn around and say recruitment notification itself is bad. After having participated in it. That was, if you like, Madan Lal is in fact quoted by the learned single judge, in the earlier round, which your lordships will find, at page number 89,
Yes. Yes.
Page 89.
Yes.
Thus, the petitioners took a chance to get themselves selected at the
9, where you are reading.
789, the quotation, I'm so sorry, quotation. 89 of the writ papers,
No, writ papers you are reading.
I'm so sorry, yes, 89 of the writ paper. On the earlier occasion,
This is a single judge order.
yes, single judge order which was set aside.
Yes.
Since the contention is having participated, I can't.
Yes.
Within the quotation,
Yes.
thus the petitioners took a chance to get themselves selected at the said oral interview. Only because they did not find themselves to have emerged successful as a result of their combined performance, both at written test and oral interview, they have filed this petition. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or selection committee was not properly constituted.
Yes.
Now, my lords, there he participates in the written test, goes to the interview.
In that earlier round, you have not participated. Before that, only challenge.
My lords, after the written test, only in the written test, we got to know there is negative marking.
Then you have challenged.
Then we challenged.
That's what that consideration of division bench.
Yes, my lords. Now here, even before the written test, the first writ petition is filed. My lords, even before your lordships, my lords, the interim order is registered saying that look, later selection go on. Now, my lords, they can't raise a contention having participated because, my lords, not in respect of my client, as a third person, I cannot challenge this recruitment because I have not participated. Now, if I file the application, they can't say you have filed the application, therefore you are out. Only a participant, before he takes a calculated chance to get selected, can challenge it. Page 90, that is where they say. In Tajveer Singh, they quote, it is therefore tried that candidates having taken part in the selection process without any demur or protest cannot challenge the same after having been declared unsuccessful.
Yes.
Now, my lords, as on today, there is nobody who is declared unsuccessful because there's only a score list at the most and verification, document verification, nothing more. Therefore, my lords, my submission is, if your lordships were to take to my list of citation, my lords, the first judgment would show, my lords, first and the second judgment are for the proposition that the recruitment rules will prevail over the advertisement notification.
Yes.
Because their contention today is that I have filed my application pursuant to the recruitment notification, therefore I can't challenge it.
Yes.
Only because I have filed the application, relevant paragraph would be paragraph 21 and 24, Manoj,
Yes.
which is at page number 6 and 7, Manoj.
Yes. Yes, we'll continue.
Yes, I'm so sorry. I'll just read these documents and close it.
Yes.
Great.
ನಂದು ಸ್ವಾಮಿ ಒಂದ್ ಮನವಿ ಇದೆ ಸ್ವಾಮಿ.
ಏನಪ್ಪ?
20 ದಿವಸ ಇದೆ ನನ್ನ ಸರ್ವಿಸ್ ಸ್ವಾಮಿ. 22ನೇ ಇಸ್ವಿಯಿಂದ 4 ವರ್ಷದಿಂದ ನನಗೆ ಸಂಬಳ ಎಲ್ಲ ಬ್ಲಾಕ್ ಮಾಡಿ ತುಂಬಾ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. 25 ದಿವಸ ಇದೆ. ದಯಮಾಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು ಪ್ರೀವಿಯಸ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪೋಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರಿ, ಮೆಮೊ ಇಲ್ಲ ಅಂತ ಪೋಸ್ಟ್ ಮಾಡಿ ನನಗೆ ಅನುಕೂಲ ಮಾಡ್ಕೊಡಿ ಸ್ವಾಮಿ. ಇಬ್ರು ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇದೇ ಬರೋ 40 ಬೇಕು ನೆಕ್ಸ್ಟ್ ವೀಕ್
40.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಸ್ ನಾಯಕರ ನಾಯಕ
ನೋಡಿ ಥ್ಯಾಂಕ್ ಯು. ಮಾರ್ಚ್ 2 ಹೇಳಿದ್ದಾರೆ ಸರ್. ಮಾರ್ಚ್ 2
ಸರ್ವಿಸ್ ಅನ್ನು ಮುಗ್ದೋಯ್ತು ಸ್ವಾಮಿ. ಸರ್ವಿಸ್
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ
ಸರ್, ಸರ್ವಿಸ್ ಅನ್ನು ಮುಗ್ದೋಯ್ತು.
ಸರಿ, ಮಧ್ಯಾಹ್ನ ಬಂದ್ಮೇಲೆ
ಕೆಲಸ ಆಯ್ತು.
ಆಗಿದೆ 10ನೇ ತಾರೀಕು ಬರೋದು. ಮಿಸ್ ಆಗಿದೆ, ನಮ್ಮಲ್ಲಿ ಮಿಸ್ ಆಗಿದ್ದು ನೋಡಕ್ ಹೇಳಿದ್ರು, ನೋಡಿದ್ದೀನಿ, ಸಾಹೇಬ್ರ ಗಮನಕ್ಕೆ ತಂದಿದ್ದೀನಿ. 10ನೇ ತಾರೀಕು ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಬೇರೆ ಬೇರೆ ನಿಮ್ದು ಅದಾದ್ಮೇಲೆ